Someone make it make sense.
Probably a couple.
Hello, squirrel friends of the world. Y'all, I'm really excited to do this. This live stream has been a long time coming. We've talked about it before. And every time plea deals have come up, I keep saying, I could do a whole live stream on plea deals. And honestly, with a lot of the research that I have for you guys and everything, it might even be more than one live stream that we end up splitting this into. We will just have to sort of see. But welcome to Frank's, welcome to Flash, welcome to Mary. Happy to see y'all. This is going to be really interesting, and I'm excited to take a look at some of the different things here and the different considerations, as it says in the title, the pros, the cons, the impact on the criminal justice system, and what does the research show? Welcome on in, Bunny. Hello, hello. Happy to see everybody. Hope you all are having a great day. Happy Annie, long time no see. Hope you're doing well. Did you have a back surgery? This would have been maybe a couple weeks ago, but let me know. Let us know how you're doing, whether you had a back surgery or not. We hope you're doing awesome. So, I need to send Twiz his special text. You guys, I need to just automate that somehow. Let's see here. Oh, not yet. Mary's saying, or Happy Annie is saying to the surgery. Okay. Well, hopefully, what do you know when you have it? We will be definitely sending all the positive vibes your way, of course. Of course. For anyone who missed it last night, we did a live stream with Twin Flames. They're back and better than ever. No, sorry. Under investigation more than ever. That's the one. That's the one. Welcome, Doug. Happy to see you as well. So Doug is saying, so glad you're breaking this down. Too many mixed takes out there. Law's got rules and you can't cherry pick what applies. Absolutely. 100%. Truth and Justice with True Crime with Anna is here. Welcome, welcome. And the other thing I'm going to do is I'm going to make a list. I already have a couple questions in mind to ask the defense attorneys who I am working for and ask them tomorrow. Because, we'll talk about it. But I thought, you know what, I should have, this wasn't like planned ahead of time. I had this idea to do this live stream like maybe 2 hours ago or something. Had I thought of it earlier, I would have asked them today, but I will ask them tomorrow. I've got some good questions for them because they deal with this question all the time. Is this the purge? This is the Scourge, combination of purge and squirrel. I don't know. And by the way, last night on the live stream, we talked about a RICO coin, and I've made it, and I need to add it as an emoji for the members, but I can show you guys it. Let me show you guys the RICO coin. Y'all will love it. Let's see here. It's a good one. This was a lot of fun to make. I know Heather wants to see this. Heather, where are you? All right, give me a second. I just have to unshare, reshare. So again, I'm going to add this as an emoji for the members. What do you guys think? TFU, so Twin Flames Universe RICO coin. There it is. There it is. What do y'all think? Y'all like it? Iowa, welcome. Long time no see. Happy to see you, my friend. ABC's docket is here. Also happy to see you as well. Love it. Reunited, and it feels so good. I know there's been a lot going on and a lot of different live streams going on, a lot of people and a lot of things. So I appreciate you guys being here. And I'm very happy that y'all are here as we talk about this really, 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 really important topic of the role of plea deals. It's really important. And, part of what, as I think about this topic, I try to think about what would be a solution, right? Is there a better solution? And I haven't come up with one yet, but I'm wondering if we won't sort of contemplate that and have some ideas just for the sake of, thinking about it as we go forward. And also, again, something else that I will add to my list to ask Scott and Chris tomorrow. So Flash says he's not feeling well. Flash, what's going on? Hope you're okay. We love you. So, and actually I should write it down. I should make a list and write it down. Make a list and check it twice. So, let's see here. In fact, I might have actually gotten a text from Scott because I did ask him one of my questions earlier tonight. So, okay, let me go back to where we were. Boop, 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 boop. All right. So Flash thinking he maybe ate some bad Chinese food. Well, I hope you're okay. You've got your squirrel friends to send you all the love and good vibes. Welcome, P. Fox. Happy to see you as well, my friend. All right. So like I said in the description, we're going to start off actually with the basics. All right. So overview. All righty. Many successful criminal prosecutions. Oh, and by the way, I didn't say welcome to Twiz and shout out to Twiz. Glad you're here. Glad you got your special text. Many successful criminal prosecutions in the United States, and not with jury trials, but with plea bargains. Plea bargains are agreements between defendants and prosecutors in which defendants agree to plead guilty to some or all of the charges against them in exchange for concessions from the prosecutors. These agreements allow prosecutors to focus their time and resources on other cases and reduce the number of trials that judges need to oversee. In plea bargains, prosecutors usually agree to reduce a defendant's punishment. They often accomplish this by reducing the number of charges of the severity of the charges against defendants. They may also agree to recommend that defendants receive reduced sentences. So what that means is sometimes it's like if somebody's been charged with, I don't know, like, you know, in North Carolina, there's like different levels for all the different crimes. True everywhere, right? But like there's like A, B, and C level for a lot of different crimes. And so let's just say it's like, you know, the class A for burglary, for example, right? They might reduce it to a class C instead, right? Or it might be that somebody's got burglary and, you know, indecent exposure and, you know, unlawful possession of a firearm, whatever, numerous different charges. And it might be that they just drop a couple of those, but they don't reduce anything. So different options, right? They can chuck away some of the charges, or they might just reduce the severity or the level of certain charges, right? And all of that, why? Because they're going to receive lesser sentence, right? Some plea bargains require defendants to do more than simply plead guilty. For example, prosecutors often offer favorable plea bargains to defendants who agree to testify for the state in cases against other defendants. We've talked about this a lot, how that's one of the, for those of you guys who missed it, we've talked a lot about how plea bargains are a lot like a contract and there's leverage, right? And so oftentimes where you see these, Adelsons are a great example, right? Like, for example, like your Katie McVanois, although she didn't take the plea, she should have. But you oftentimes see it when you've got more than one defendant, whether it's co-defendants or you've got unindicted co-conspirators, like with the Adelsons, where, you know, they will turn somebody else into like a key witness, right? For throwing somebody else under the bus, essentially testifying for the state, or providing them other important evidence. Another example in the Shannon Gardner case, right, with Henry Tenon, very controversial there. Speaking of controversial plea deals, that one is a whole thing. Is Denise here? I would love to see Denise. We've missed Denise. Idaho Rule 11. I forget what Idaho Rule 11 is. And 32.1. We can look at those, though. I mean, this ring, I'm just trying to remember. Oh, okay. I see. Idaho Rule 11, 32.1. Let me see. I'm going to pull these up as well. Okay, we can actually take a look at those. Let me finish reading this description of the plea bargain here, and then we'll take a look at these, Doug. Who is Miss Benoit? I don't know what that is. Please. Okay, so, all right, so where was I? So, right, testifying against other defendants, right. According to the Department of Justice's Bureau of Justice Assistance, The overwhelming majority, 90 to 95% of cases result in plea bargaining. So just wrap your heads around that, guys. 90 to 95% of criminal cases, right, result in a defendant pleading guilty. 90 to 95%. It's really akin in civil trials where it's like settling, right? I would say that percentage is probably about the same in terms of cases settling when it comes to civil trial. PSI is the pre-sentencing investigation, and you can waive that in Idaho. Lori Vallow also waived her PSI report. And I think the reason that they said in the hearing that he was going to waive it, because they said something like, what did they say? There's been enough already done in that realm or something to that effect. My interpretation was that because there's already been so many like examinations, like they've already had all the different people examine, psychologists and whatnot, and medical history. Essentially, my interpretation was they've basically already gone ahead and done a lot of that legwork that would have been done in a pre-sentencing investigation. I don't know who's Katie Benoit. I don't know what that is. Twist Katie Benoit. I don't know what that is. So okay. So 90 to 95%. The role of judges. Okay. In some jurisdictions, prosecutors and defendants can work with judges to predetermine what sentence the defendants will get if the defendants accept plea bargains. In most jurisdictions, however, judges' role in plea bargaining is limited. For example, federal judges retain final authority over sentencing decisions and are not bound by prosecutors' recommendations, even if their recommendations are part of plea bargains. Similarly, federal judges may not be directly involved in plea bargain negotiations. Controversy surrounding plea bargains. Although plea bargaining allows the criminal justice system to conserve resources, right? Just like with civil trials and settling, right? Because going to trial is expensive. The plea bargains are controversial. Some commentators oppose plea bargains as they feel that plea bargains allow defendants to shirk responsibility for the crimes they have committed. I'm going to highlight it so you guys can see what I'm reading. Others argue that plea bargains are too coercive and undermine important constitutional rights. Plea bargaining does require defendants to waive 3 rights protected by the Fifth and Sixth Amendments: the right to a jury trial, the right against self-incrimination, because they have to plead guilty, and the right to confront witnesses. The Supreme Court, however, in numerous cases, such as Brady v. United States, has held that plea bargaining is constitutional. The Supreme Court, however, has held that defendants' guilty pleas must be voluntary and that defendants may only plead guilty if they know the consequences of doing so. Notice that it doesn't say that they have to actually be guilty, right? They can only plead guilty if they know the consequences of doing so. Essentially, what rights are they giving up? Okay, so that's basically the rest that we need here. Now we're going to go on to this one. So this is from the American Bar Association. All right, how courts work. Steps in a trial. The very first thing is plea bargaining. Notice. Many criminal cases are resolved out of court by having both sides come to an agreement. This process is known as negotiating a plea or plea bargaining in most jurisdictions. It resolves most of the criminal cases filed. Plea bargaining is prevalent for several reasons. First of all, defendants can avoid the time and cost of defending themselves at trial, the risk of harsher punishment, and the publicity a trial could involve. The prosecution saves the time and expense of a lengthy trial. So first thing here you can think of as a takeaway: resources on both sides. Resources, money, so time and money, so resources saves both sides resources, right? Both sides are spared the uncertainty of going to trial. And the court system is saved the burden of conducting a trial on every crime charge. And I'm sure this will come up in some of the other things we're going to take a look at. But in other words, if this is where I was saying, like, what is a better solution? Because if plea bargains didn't exist, there's a number of things that would occur. But as far as this topic is concerned, in terms of resources, the first thing that would happen is the criminal justice system would probably implode, because there is absolutely no way that every case can be tried. There's just not enough resources, not enough like the court system would, implode. Either side may begin negotiations over a proposed plea bargain, though obviously both sides have to agree before one comes to pass. And typically it comes from the state. Plea bargaining usually involves the defendants pleading guilty to a lesser charge or to only one of several charges. It may involve a guilty plea as charged, with the prosecution recommending leniency in sentencing. The judge is not bound to follow the prosecution's recommendation. Plea bargaining is essentially a private process, but this is changing now that victims' rights groups are becoming recognized. Under many victims' rights statutes, victims have the right to have input into the plea bargaining process. Usually the details of a plea bargain aren't known publicly until announced in court. Okay, other alternatives, guys. Other alternatives are also possible in the criminal justice system. Many states encourage diversion programs that remove less serious criminal matters from the full formal procedures of the justice system. Typically, the defendant will be allowed to consent to probation without having to go through a trial. If he or she successfully completes the probation, for example, undergoes rehabilitation or makes restitution for the crime, the matter will be expunged, removed from the records. Okay, so now before we move on to what the legal scholars have to say on the issue, we'll take a look at what Doug was mentioning. So this is Idaho Rule 11. Okay. So signature, every pleading written motion must be signed, representations by the court, sanctions. And I'm sure, let's find the part. What part, Doug, were you referencing here then? Hold on. Because I'm not seeing anything about pleas here. Sanctions. Am I missing something? What are we looking at here? Pleading. Everything has to be signed. I'm forgetful. I'm not forgetful. I'm just not seeing anything here. This is what I thought that this was going to be referencing plea bargains or plea deals. This is talking about pleadings as in motions, essentially, right? Or pleadings, but not necessarily plea bargains. So I'm not quite sure what Doug was referencing with this specific rule as it pertains to plea deals. I'll see if he's still listening and can let me know what on this was specifically relevant. But in the meantime, we'll go to the next one. Okay, so this is Rule 32. Deals with plea deals, how they're made. I don't see anything about, Doug, I'm on Rule 11. I'm not seeing anything about plea deals on here, though. Oh, 11D to be, thank you. 11. How come I don't have a D2B? I just have a D. You see what I'm looking at here? This rule does not apply. I don't have a D2B. I just have a D. So I don't know. Where is it? How come this is the this should be, this is the idaho.gov. How come there's not a D2B? There's just a D. So as far as this one goes, public has a right to access the judicial department's declarations of law and public policy and access the records of all proceedings open to the public. Yeah, how come, Doug, how come D2B was not, it just had D and there was no 2 or B on there? How come it's not on there? Court record, physical record, applications. Access to court records, pleadings. Yeah, it's not, Doug, I know how it works with subsections. I'm just saying that, look. So there's subsection D. It doesn't have a 2 or a B. It's just standalone. You see what I'm saying? I don't know why. From the federal rules. Oh, I thought you were talking about specifically Idaho rules. Okay, I've got the federal rules right here. Hold on, let me pull that up. hang on. I've got it in I've got the book actually for that. So let's see. I thought it was Idaho. My bad. Let me do it this way so you guys can see it instead of using my book. Okay, let's do this. Okay. So okay. So let's read some of this. So let's read the conditional plea. With the consent of the court and the government, a defendant may enter a conditional plea of guilty or no contest, reserving in writing the right to have an appellate court review an adverse determination of a specified pretrial motion. A defendant who prevails on appeal may then withdraw the plea. So let's break this down. Has to have the consent of the court and the government. So that's the judge and the prosecution. They may enter a conditional plea of guilty or no contest. And then they go on to define no contest here, no low contended. That's no contest. Before accepting a plea of no contest, the court must consider the parties' views and the public interest in the effective administration of justice. Okay, fine. So I don't know that what we saw. Now, there could be things, in other words, it seems to be using these interchangeably, right? Like a conditional plea of guilty or no contest. I don't know that that's what we had here, but let's say we did. Let's say there was a conditional plea of guilty. Then what would need to be done? We reserving in writing, okay? And here it is, an appellate court review, an adverse determination, as in a motion, for example, getting denied, a specified pretrial motion. So if there's like one specific motion that had an adverse finding, the judge ruled and it was an adverse to the defense, they could preserve that in writing to that specific motion. And if they win on that appeal, they can withdraw the plea. Does that make sense to everybody? Considering and accepting a guilty or no contest plea, okay? Advising the defendant, we know all that. Ensuring the plea is voluntary. Determining factual basis, we saw all of that. Plea agreement procedure. Just closing a plea agreement. The parties must disclose the plea agreement in open court when the plea is offered. So here's the thing I will say about this. What this is saying is that all of the agreements that are part of the plea agreement, everything that is agreed to, needs to be disclosed in open court. So I'm wondering if indeed there had been anything like a conditional plea, right? Or they were reserving that, what we were reading up here, where they can reserve in writing a specific finding from a specific motion, right? I think we would have heard that in open court because, where was it? In other words, if it's part of the agreement, right? Anything that's part of the agreement, the parties must disclose the plea agreement in open court when the plea is offered. Unless, oh wait, keep reading. Unless the court for good cause allows the parties to disclose the plea agreement in camera. I should have kept reading. There's an exception. Unless the court for good cause allows the parties to disclose the plea agreement in camera. Now, that sounds like it might be the entire plea agreement, but it does, I mean, I suppose essentially here, this would leave open the possibility that there could have been maybe they could split the baby, so to speak, where part of the plea agreement is discussed in camera and the rest of it is in open court. I mean, Judge Hippler seems to just be, I mean, well, we all heard it, right? He just found out about it. I don't know. I'm not sure that happened, but I suppose it's possible. I just don't know that it would allow them to do that, though, like part of the agreement. It almost sounds here like it's like the entire agreement would be done in camera. Okay, here, this is this part with the to the extent the plea agreement is of the type specified in Rule 11C1A or C, the court may accept the agreement, reject it, or defer a decision until the court has reviewed the pre-sentence report. Okay. Rule 11C1A or C. Hold on. Let's go back to that. 11C1A C. Okay, so that's referencing here. Agree that a specific sentence or sentencing range is the appropriate disposition of the case, or that a particular provision of the sentencing guidelines or policy statement or sentencing factor does or does not apply. Such a recommendation or request binds the court once the court accepts the plea agreement. So in other words, what this is saying is once the court, the judge, accepts the plea agreement, then that recommendation is binding once the court accepts it. And then where was... Right, okay, and then here it is. The court may accept the agreement, reject it, or defer a decision until the court has reviewed the pre-sentence report. Okay, the key word here is may. The court may accept the agreement, reject it, or defer a decision until the court has reviewed the pre-sentence report. In other words, the court can accept it, or the court can reject it, or the court can say, hold on, I'm going to wait to make a decision on this plea agreement until I've reviewed the pre-sentence report. Why? Because once they accept it, it's final, right? Like we just read. And then if the court rejects a plea agreement containing any of those provisions, wait, hold on, I forgot to read this part. If the court accepts the plea agreement, it must inform the defendant that to the extent the plea agreement is of the type specified in those rules we just looked at, the agreed disposition will be included in the judgment. So in other words, if the court accepts it, then the agreement will be the court has to inform the defendant, right, of what they agreed to, which we heard. And then rejecting, if they reject it, the court must do the following on the record in an open court if they reject it. Oh, we have a new scroll friend, the Wandering Orphan. Welcome on in. Hello, hello. If he withdraws, it's still an admission of guilt. Let me ask you a question. Do you mean, are you just saying like it's an admission of guilt, so like he said he was guilty, or are you getting at the implications that this could have because it would go to trial and how that would affect the trial? Because I can speak on either of those issues, but he can't withdraw it because he already, Hitler already accepted it. But what I was going to say is this: that's why at the hearing, that's why the pre-sentencing investigation came up, right? Because Judge Hitler is putting on the record that the parties decided he could go ahead and accept the agreement instead of waiting on the pre-sentencing investigation. Remember, it said may. The court may accept it, reject it, or say, I'm going to defer until a PSI, right? And what happened was he said, I'm going to accept this, and the parties are waiving the PSI, so which means he can go ahead and accept it. And does that make sense, guys? Let me scroll up and see what you guys are saying in the chats. As you all know, it's hard to read the chat while I'm reading on the things. So, so where is the discovery? I'm going to keep looking for the discovery part here. It could be. I don't know. So Doug's asking a question. Couldn't this be a way to force the state's hand to what state actually has? I have to find that to better answer that question. I haven't seen anything about the discovery yet. We're still here with the pre-sentencing investigation. Oh, okay. Let's take a look. Withdrawing a guilty or no contest plea. Okay. A defendant may withdraw a plea of guilty or no contest, 1, before the court accepts the plea for any reason or no reason. Well, it's too late for that. Or 2, after the court accepts the plea, but before it imposes sentence if. Okay. So this is where we're at, right? The court has accepted the plea, but there's not been a sentencing yet, right? So if A, the court rejects a plea agreement under the other previously read rules, well, that hasn't happened, the court accepted it. Or B, the defendant can show a fair and just reason for requesting the withdrawal. Okay, a fair and just reason. I'm sure it'll tell us what those are. After the court imposes the sentence, the defendant may not withdraw the plea. Okay. The admissibility. So here, what this is saying is that the pleading guilty. Okay, like let's just say that hypothetically, he withdrew the plea, and then they go to trial. Him having pled guilty in open court is not admissible in trial, right? Let me see if I can control F myself for discovery. I'm not even seeing discovery mentioned at all on here, Doug. I just did a control F myself and there's no discovery. So I'm not sure where did you see that about the discovery? The other thing I want to look at is, where was it? For good cause. Hold on. Where did it take me to on here? Holy shit. Oh my God. Okay, let me just do this better. Oh my God. These are all the committee notes. Okay, so fair and just reason for requesting the withdrawal. Hold on. Okay, a defendant may withdraw a guilty plea before sentencing for a fair and just reason, such as ineffective assistance of counsel, lack of mental competence, or coercion. I'll say those again. So ineffective assistance of counsel. I don't think he can go that route because it's on the record a million times that he was happy with cancel. Lack of mental competence. Don't think they can go that route. Or coercion. I don't think they could go that route. Let me just see here. And again, it's different before the judge accepts it. Before the judge accepts it, remember, before the judge accepts the guilty plea, you can withdraw for any reason. After the judge accepts it, but before sentencing, you have to have the fair and just reason, and that is far more limited, it looks like. Yeah. Let me look at what the ABA says here. This is interesting. So that by pleading guilty, the defendant generally waives the right to file further motions in the trial court, such as motions to object to the sufficiency of the charging papers, to state an offense, or to evidence allegedly obtained in violation of constitutional rights. That by pleading guilty, the defendant generally waives the right to appeal, except the right to appeal a motion that has been made. Like we just covered that, right? So a specific motion. It looks like it's like they get one motion, right? Other than that, they waive the rights to appeal. Ruled upon and expressly reserved for appeal, just like we read previously here. Determining voluntariness of a plea. And I mean, we heard that, right, in the colloquy, right? Has anyone influenced you to do it? Da da da. He said no. Determining the factual basis. The offer of a defendant to plead guilty should not be refused solely because the defendant refuses to admit culpability. Wow. Okay, let's take a look at this withdrawal of the plea. Let's see what the ABA says here. So after a plea of guilty or no contest and before sentencing, the court should allow the defendant to withdraw the plea for any fair and just reason. Again, with the fair and just reason. In determining whether a fair and just reason exists, the court should also weigh any prejudice to the prosecution caused by reliance on the defendant's plea. After a defendant has been sentenced pursuant to a plea of guilty or no contest, the court should allow the defendant to withdraw the plea whenever the defendant, upon a timely motion for withdrawal, proves that withdrawal is necessary to correct a manifest injustice. Okay? A timely motion for withdrawal is one made with due diligence. So, of course, it's not specified, considering the nature of the allegations therein. Manifest injustice. Okay, here we go. Withdrawal may be necessary to correct a manifest injustice when the defendant proves, for example, that A, the defendant was denied the effective assistance of counsel guaranteed by the Constitution, state, or rule. B, the plea was not entered or ratified by the defendant or a person authorized to do so on the defendant's behalf. C, the plea was involuntary or was entered without the knowledge or charge or knowledge that the sentence actually imposed could be imposed. In other words, they don't have a knowing, they weren't knowing involuntary, right? D, the defendant did not receive the charge or sentence concessions contemplated by the plea agreement, and the prosecuting attorney failed to seek or not impose these concessions as promised in the plea agreement. So, for example, the prosecution's not holding up their end of the bargain, right? E, the defendant did not receive the charge or sentence concessions contemplated by the plea agreement, which was either tentatively or fully concurred in by the court, and the defendant did not affirm the plea after being advised that the court no longer concurred after being called upon to either affirm or withdraw the plea, or the guilty plea was entered upon the express condition approved by the judge that the plea could be withdrawn if charge or sentence concessions were subsequently rejected by the court. So this sounds like that conditional type of guilty plea that we referenced earlier. The defendant may move for withdrawal of the plea without alleging that he or she is innocent of the charge to which the plea has been entered. Let me read that one again. The defendant may move for withdrawal of the plea without alleging that he or she is innocent of the charge to which. So in other words, you can withdraw a plea without being like, it's because I'm innocent or whatever. But that still is subject to all the other prior, what's the right word? Circumstances that have to be met, right? As an alternative for allowing the withdrawal of a plea of guilty or no contest, the court may order the specific performance by the government of promises or conditions of a plea agreement where it is within the power of the court and the court finds in its discretion that specific performance is the appropriate remedy for a breach of the agreement. Withdrawn plea and discussions not admissible. A plea of guilty or no contest that has been withdrawn should not be admitted as evidence against the defendant in any criminal or civil action or administrative proceedings. So that's what I was saying earlier. Again, this is just sort of elaborating. Should not be admitted if they withdraw the plea. Plea discussions and plea agreements here. This is going through the different options. Again, we've covered this already. The prosecuting attorney should not, because of the pendency of plea negotiations, delay any discovery disclosures required to be made to the defense under applicable law rules. So, for example, if they had a motion to compel still with outstanding, right, and they were still waiting on discovery, but there's already a plea deal in process, it doesn't mean they can just not turn that shit over, basically, right, or delay it. Responsibilities of defense counsel. Responsibilities of the judge. A lot of this I'm skipping over because we've already covered it from the other places there. Okay, withdrawal of the plea shall be allowed if the judge had previously concurred. Hold on. Oh, this is a lot of, again, sorry, this is redundant. We've already covered a lot of this. Hold on, let me just keep going. Let's see here. Inadmissibility. Can't bring it up in other proceedings. Here's the diversion. So let me see what you guys are saying in the chat. Okay, let's take a chat break. And I also didn't do a proper Nightbot welcoming for our new squirrel friend, Wandering Orphan. Also love that name. Let's see what you guys are saying. So the plea, again, remember, there's two things, right? Before the judge has accepted the plea deal, the defendant can withdraw for any reason. But after the judge has accepted the plea deal, but before sentencing, which is where we're at now in this case, the defendant can still withdraw, but they have to have, what was it, just cause, right? They have to have a really good reason, basically. Right. So Doug is saying it's not just about what was said in court, it's about whether the defense had all the evidence they were entitled to before advising the plea. I will say that in the colloquy, before the colloquy to Bryan, there was the colloquy to Ann Taylor, and he asked her, do you feel like you've had enough time to review all of the discovery in this case? And she said yes, which I found surprising. And then he also asked the question to Bryan, and Bryan also said yes. But more importantly, Ann's answer to that makes it sound like they got all the discovery and there's nothing withstanding, and that they've had a chance to review it all. That's what that sounded like. I mean, that was in the hearing. Welcome, Kane. Glad you're here. Why did the state plea if they had such a good case? Well, Twiz, you know my thoughts on this. The reason the state pled is because they admittedly don't have a good case. Like, that's the only reason. We've talked a lot about this and how it works with the leverage, right? The state has to have something to gain. I've talked about this at length, so I'm not going to bore you guys by repeating myself, but I'm sure you guys know my thoughts on that. So maybe that question was not for me. What evidence do they have that could prove him guilty? That's in the eye of the beholder in terms of the jury. And again, my thoughts on that are that the defense's concerns, and from what my opinion and the opinion of many other people who weighed in on this in terms of the risk you take with a jury, is there's a lot of jurors out there who would hear DNA on the knife sheath and they would stop listening to everything else, and that would be enough for them. I've talked about it a lot, right? Richard Allen jury, for example, versus a Karen Reed jury, So, and I'm not saying that should be sufficient. I'm not saying that. You guys know I'm not saying that. But a juror, scary thing, right? But like, unfortunately, there are many jurors who that would be it, and they wouldn't even care. Please don't tell me this is a pro BK channel. So here's what channel this is. This is where we're the Squirrel Crew. I aim to bring. I don't take sides like that. I don't think that's really helpful. You guys are welcome to believe whatever you want or not believe whatever you want, obviously. But as far as me, I aim to just analyze everything from the legal perspective as objectively unbiased and unbiased as possible. And I'm sure that probably some of y'all in the Squirrel Crew in the chat would say that is, that's what this is about. I analyze everything again, as objectively unbiased as possible. So I don't think about the way that I assess any case in any trial isn't, do I personally think a person did a thing or not? I assess it from, can the state prove it beyond a reasonable doubt? Because that's the question that will be before a jury, and that's the question that matters. So And the thing that I always say to everybody, right, is if you want to make a determination of if you think somebody is actually, factually innocent or not, which again, isn't really the question for the jury, but if that's something that people want to do, I always say keep an open mind, because that just, if you're going to make that choice, that should happen at trial, because we don't have all the evidence. In any case, we don't have evidence until trial, right? Now, in this case, we're not going to have a trial. So we're never going to see all the evidence. But I don't understand how, in any case, people can be so sure one way or the other when we haven't seen all the evidence. And as I always say, especially in this case where so much has been, sealed. There are some cases where a lot of the evidence has been brought forth publicly prior to trial, but that still isn't everything, right? We always want to keep an open mind before trial. Oh, thank you, Flash. Flash says this isn't a pro anyone channel. Yeah, this is a pro squirrels channel. If I'm pro anything, I'm pro squirrels. I mean, that's not even an if. I am pro squirrels. Tonka, thank you so much. This means the world to me. Tonka says Chelsea's probably one of the most objective creators on this platform in regard to crime content. Tonka, that means so much to me. Thank you, thank you, thank you so much. Thank you so much. I appreciate that. I really strive for that, so that means a lot to me. We are on the side of, we're big fans of justice here. We're on the side of the law, 100%. It's not about siding with anyone. Is she gone? Well, for anyone who's listening, for anyone who's new, right? I mean, it's important because there are a lot of people that, and I'm not saying there's anything wrong with it, right? There's every channel, do you, right? And it's totally fine to take a stance. But for me, and the way that I see so much value, and part of the reason why I love doing this is because of how it really helps us, myself included, to constantly reassess how we're viewing things and to keep an open mind. I think, as I've said, I say it all the time, I think that by watching trials and by reading court filings and analyzing everything from the legal perspective, I think it makes us better people. And to think analytically, right? Again, keeping an open mind, being objective. These are all skills that are so difficult to maintain, I feel like, especially the older you get as you're an adult. And it's challenging. It's challenging, right? But I think it's a challenge that is worth striving for. So that's why I strive for it every day. And I tell you what, it's been great because with my new job, each and every day, I feel like I am only just exponentially increasing what I already had in terms of my ability to do that, just the legal mindedness of it all. And anyways, so yeah, and happy to see you, Tonka. Long time no see. I saw you in Keynes earlier. So, okay. So yes, but welcome anyone who is new. Yeah, but as far as the discovery goes, my only concern with that being something that would be a grounds for anything would be that in that colloquy, both Anne and Bryan said that they'd reviewed all the discovery and they'd had enough time and all that, right? That's the only concern I would have with that being an issue. Now, having said that, it doesn't mean that there couldn't be, again, a standalone motion as has been referenced that they are reserving, right? But I do think if that was the case, we probably would have heard it in open court. But we will see. There's still some time, right? We've got several weeks before sentencing. We'll see what happens. So yeah. Yeah, if there's new discovery, that's a great point. Totally. Yeah, if there's new discovery, that would be crazy, wouldn't it? So, and happy that the rat daddy's in the hizzy. Okay, so now we're going to jump over to this. I've got a couple really interesting things here. Okay, I've got coercive plea bargaining, the unrecognized scourge of the justice system. And how I got kind of thinking on all this, right, was the way I got thinking about all this was I got thinking along these lines, right? I got thinking along the lines of if you are a defense attorney and you've got a client who you believe is factually innocent, okay? And you, as one does, count through all your discussions and you're counseling them, right? And they decide to take a plea deal, again, which is 90 to 95% of criminal cases, right, resolve with a plea deal. So they plead guilty. And so you've got to, let's just say you've got a defendant who is factually innocent, right? But because the plea deal is the best offer, right? It'll, again, reduce sentence, all these different factors. You encourage them to take plea deal, and then the defendant in open court, says on the record, yeah, I plead guilty, da, da. What I started thinking about is, like, what is the role of the defense attorney? Because do you get into an area there where they could be actually like eliciting false testimony in a way? Not that it's testimony, right? But I was just thinking about this myself of like, is there a gray area with like them counseling their client and the client, like, but if the client is admitting to something they didn't do, right? Are we there in a problem of like, again, eliciting a false statement or perjury or anything like that? Like, just it's more like a philosophical exercise, because we know that there's people who are innocent that plead guilty all the time. So that's why I was like, how does the law work? How does the law make room for this? But we're gonna talk about that. Did Mary go to bed? Good night, Mary. We love you. Tonka says, usually watching on replay. Appreciate the facts I bring in many different cases. Well, you're very welcome. I'm glad you appreciate it. Yeah, rights matter. 100% rights matter. We love people's rights here being appreciated and withheld and upheld, rather. So, okay. Look at this, guys. Y'all, I've got so much stuff here. That's why I said this might be multiple live streams. Overcharge. Let's take a look at this. Overcharging, the precursor to coercive pleas. Let's take a look at that. Page 83. Okay, so we're almost there. And I should probably zoom in. Looks like the plea bargaining emerged in the second half of the 19th century. Interesting. It won't let me scroll. Why won't you let me scroll? Come on. Adobe's having a moment, I guess, or Chrome. And one of the questions that I have, let me see if Scott texted me back. One of the questions that I had for the defense attorneys I work for that I'm going to be really curious. So let me just say this while this is loading. So I will say that, I've been at the law firm now for a little over a month, I guess a month and like 2 weeks or something. And one thing that has become abundantly clear to me is that in all these different cases, they've got federal, they've got state. Again, many of these cases are murder cases. Okay, guys, first degree, second degree. And even just in casual conversation, what I can say that is with any of these cases, or even if it's a lesser charge, with all of these different cases, whenever it's just casual conversation or whatever, everything that I've heard from so far from both these defense attorneys, who are excellent and very, very, very experienced and phenomenal at what they do, they always are aiming for a plea. Like, everything that they're talking about is like hoping that they can get the prosecution to agree to a plea deal that the defendant will be happy with. Like, in other words, it's like pleading is the goal. So one of the questions that I have for them is, has there ever been an exception? Like, has there ever been, and I would imagine the answer is probably yes, but I'm going to be curious to find out circumstances. Has there ever been a case where you felt like taking the case to trial was the right option, and that accepting a guilty plea was not in the best interest of the client? Like, because what I can tell is, like, for 100%, it's like accepting a plea deal, right, is like, seems to be almost always in the best interest of the client. And that's why we see 90-95% pleading guilty, right? So my question is like, I want to ask them, like, has there ever been a time where you were like, no, that's not the right option? Like, of course, it's always the defendant's choice, right? But in terms of what they view to be in the best interest of the client, it's like, this needs to go to trial. So that's what I'm going to be really excited to find out from them and see what stories they have. And look, somebody gifted memberships. Was that Kane? Kane gifted 10 memberships. Thank you so much, Kane. And Kane also became a member. Awesome. Love it. You guys have access to all those custom emojis. And again, I will tonight get the newest one added to the group there with the RICO coin. Can I do a discussion on the death penalty in Idaho? Has the same issue that Idaho has? I suppose so. I mean, I've discussed the death penalty in general on a lot of live streams, and Idaho specifically on a lot of live streams. I'm sure I've had several live streams that were literally just discussing the death penalty. But if you have a specific question or something in mind, let me know. Let's see here. Twiz saying he's standing with ATSG. I agree. I think AT is phenomenal. And in fact, I heard somebody say, who was it? I forget. It was somebody on LawTube was saying that actually, I think it was EDB or Lawyer You Know, because she was on his show and I was listening to this while I was like driving to work. But one of them, either Lawyer You Know or EDB, one of the two said that they thought that his team, Bryan Kohberger's defense team, was like better than a lot of defense teams that you could buy if you had all the money in the world to hire private counsel. Like they were saying it's like one of the best, like one of the strongest defense teams that they've seen in terms of like, you know, this case and the death penalty. And like they're speaking about Ann Taylor. And I would agree. I would totally agree. I think she's done an amazing job. And as we know, if you've got a death penalty case and you're the attorney, your goal is to save the client's life. And so when you look at it that way, again, I know it's really hard, but if you take it just one thing at a time, and you just literally assess it from that angle, this is a success, right? Because they've saved his life. Like that is their goal. And that is the goal that they've had this entire fucking time. And they have succeeded at this juncture, right? In saving his life. So, okay. It'll let me scroll again. Woo! Okay, so we're going to page 83. Overcharging, the precursor to coercive pleas. Let me zoom in for you guys. I know Kane will appreciate that, among other people. Okay, so when it says commentators, it's referencing people that are like legal scholars. Like what this article and the next one we're going to look at were written by like law professors, right? So when they say commentators, they're talking about other law professors. They're not talking about like YouTube commentators, by the way, guys. Some commentators suggest that prosecutors do not overcharge to obtain harsher sentences than the accused's conduct merits, but rather to gain bargaining leverage. I would say that is accurate. Such naivete provokes two responses. One, look at all this. Look at all these footnotes. Regardless of motivating factors, overcharging violates prosecutorial ethics in and of itself. Okay, let's break that one down. All right, let me go back up. Let's look at this. Look. Okay, so let's break it down. What this is saying is that some people would suggest, and I would agree with this suggestion, that some prosecutors will overcharge so they can have bargaining leverage to make a plea deal. The first point they're making here is that this would violate the ethics of a prosecutor, because why? They should never be bringing a case to trial, or they should never even be charging in the first place. They should never be overcharging in the first place. Like what this is saying is they should not be overcharging in the first place, right? They should only be bringing charges that they feel like they can prove beyond a reasonable doubt. So they shouldn't. So you guys, this is a huge point, because it's like this shouldn't be happening, but this is happening, right? You guys see what I mean? This just makes me so upset, guys. This makes me so upset. Oh my god. Okay, and then part 2. Overcharging sets the stage for coercive pleas by virtue of the very leverage unduly obtained. Yup. So in other words, right, let's just say that you, I don't know, let's just say that you were shoplifting, right? And you stole a bag of candy from a Walmart. I don't know, right? And let's just say that the state overcharges you with like, I don't know, the highest, a lot of times, at least here in North Carolina, the way that is dealt with is based on the value of the item that was stolen. So let's just say that instead of like a $2 bag of candy, let's just say that they go with the top, like, again, like the A tier, how we do it in NC, like ABC, like the A category, right? which would be like, let's just say for the sake of the example, the equivalent of stealing a fancy car, like the kind that Jeff Twin Flames had very briefly before the feds took it, like a 200,000. I mean, all the time I'm seeing a lot of these cases that we have going on. They're the amounts that are being when they're looking at sentencing and stuff, it's like $200,000 or more. So these clients that we have, a lot of them, if it's dealing with like theft or fraud, they're dealing with amounts that are well over $200,000. So I'm trying to think of an item that one could steal that is worth more than that. And I can't think of anything offhand. Can you guys? I don't know. Fancy watch? I don't know. So yeah, again, like let's just say that you stole a $2 bag of candy, but instead they're charging you with like the top tier of something that was more than $200,000 in value. And that the bag of candy would get you no jail time. It would just get dismissed and expunged, more than likely, right? If you don't have a criminal record previously. But if they charge you with the top tier, you're not going to get around jail time if that's what you end up. If a jury finds you guilty of that top tier, right? Level A, more than $200,000, for example, like you're looking at, I don't know, let's just say it's 5 to 10 years, whatever it is, jail time, right? Restitution, fees, all this stuff, right? Felony on your record, whatever the case may be. And like, but they say, well, hey, if you want to take a plea deal, we'll go with the second to lowest level. We'll go ahead and give you you stole 20 bags of candy, right? And you might be thinking, but I only stole one bag of candy worth $2, right? I didn't steal 20 bags of candy. I stole one bag of candy, right? But it's like, if your option is going with stealing 20 bags of candy, right? And maybe you're looking at 30 days in prison. I don't know. I'm just making an example, right? Versus risking your chances at trial and then you get the top tier, right? You see what I mean? So the overcharging sets the stage for coercive pleas by virtue of the very leverage unduly obtained. And again, it reiterated here that the prosecutors are violating their prosecutorial ethics if they are overcharging in the first place. So this should not be happening. But if it's happening, it's setting the stage for coercive pleas. Guys, am I making sense to you people in the chat? Squirrel crew, my favorite squirrel friends. Twiz says no stealing my candy. Love it. Hi, Heather. Welcome. DJ Flashy Flash wants candy. Also, welcome to DJ Flashy Flash. Heather says she's stealing all the candy. Do you guys have favorite candies? Put your favorite candies in the chat, guys, if y'all have them. I don't need any candy. You know why? I have cough drops. The better cough drops, the new and improved candy. Cough drops. It's the candy for the new millennium. Wait, that happened a long ass time ago. Oh my God. Can you tell I'm a 90s kid? Love this. DJ Khaled once said, the key is to stay clean at all times. Yeah, words to live by, guys. Words to live by. So Kinder Bruno, I have no idea what that even is. Is that a candy? Kinder Bruno, I can't read. Bueno bars? Is this like a combination of German and Hispanic? I don't even know. Okay. So if our criminal justice system were trial-centered, prosecutors would only have reason to file charges on which they would likely secure a conviction. Right here, it's making a point as to why the jury in the trial, why it's important, right? Check it out, right? Because what it's saying essentially is this. Essentially what it's saying is having a jury is kind of the thing that is standing between the prosecution and us, the citizens, being levied charges against us that are just completely blown out of proportion, like the example with the candy. So I'm going to read it again. If our criminal justice system were trial-centered, prosecutors would only have reasons to file charges on which they would likely secure a conviction. So in other words, this is making a great point. Like essentially, right? Like I was saying, what would it be like if there was no such thing as a plea deal? What if with every single time the government wanted to charge somebody with a crime, they knew it was going to go to trial and there was going to be put before a jury, right? The very fact that this is the question that's like, wow, how this would change things proves this point right here, that the vast majority of cases are more, I would say almost definitely being overcharged. If the prosecution is afraid that the charges are such that they won't secure a conviction, right? Here's the thing, right? Well, so if you've got a case that's going to go to trial, right? Okay, let's just say that the evidence is not so strong. You've got different options, right? You could just not go to, you could just drop the charges. Or like, what if it's a lesser, for example, like, again, the evidence that would be needed to secure a conviction from a jury on like the one bag of candy person, right? Versus the evidence that would be necessary to establish the top charge, right? The $200,000 plus theft charge, right? Think about the difference in what the type of case would have to be presented to a jury. So does that make sense? Like, if the prosecutors knew that every time they would have to bring their case before a jury, they would only be filing charges that they knew their evidence could support. I just got goosebumps. However, because most criminal convictions are secured through plea negotiations, oh my God, this is just going to get me so worked up, guys. Prosecutors have an incentive to file more serious charges than those supported by the evidence. Literally, I was just saying supported by the evidence, with the hope that a defendant will be risk averse. Let me read this again because it's really fucking important right here, guys. Literally, this is the crux of the matter right fucking here. If our criminal justice system were trial centered, prosecutors would only have reason to file charges on which they would likely secure a conviction. Remember, they should only be doing this anyway. But let me keep reading. However, because most criminal convictions are secured through plea negotiations, prosecutors have an incentive to file more serious charges than those supported by the evidence with the, quote, hope that a defendant will be risk averse, end quote. It's disgusting. Furthermore, prosecutors lack any political incentive to refrain from overcharging because most communities want the state to be tough on crime. Kane, thank you for making me laugh. I'm so mad I can't laugh out loud, like physically, but I'm laughing in my heart. Just know that. Just know that I'm laughing in my heart. Kane says, how in the Shalia is chocolate not candy? Thank you, Kane. Thank you. Chocolate is candy. Who's saying chocolate's not candy? That's blasphemy. And by the way, I love chocolate. I will say that chocolate maybe ties with cough drops for me. Yes, Bryan Kohberger. Yep, they were public defenders. Yep, court appointed. Technically, they're court appointed counsel. Does anyone want me to explain the difference between a public defender and a court appointed counsel? I'd be happy to. Let me know if you guys want to know the difference. Right. That's correct. And Tonka, I think you weren't here at the beginning of the live stream, but yeah, we already covered, there's a statistic there that we had 90 to 95% of criminal cases resolve with a plea deal. And again, it's a similar statistic to what you would have in a civil trial with settling, right, before trial. So in other words, think about it, if you think about like civil cases or criminal cases, only between 10 and 5% of either category are actually going to trial. Pretty wild, right? Too fast. Welcome on in. Happy to see you. So no one really asked me to elaborate, but I'll do it anyway because that's the teacher in me. So a public defender is somebody who works for the government, like the prosecution, right? They are salaried. Their salary is paid by the government, and they work for the government, but only to defend, right? Great example. Here in North Carolina, right, in Forsyth County, which is where the law firm is, they have, the public defender's office. And they were just telling me the other day that they are desperately in need of public defenders. Like their public defender's office is like dying, and they're desperate for public defenders here in this area, to the extent of which they may start having to transition more into the realm of court-appointed counsel, which is the other thing. So what's the difference? So like I said, public defenders are hired by the government. That's who they work for. That's who their salary. They're just like the prosecution. Court-appointed counsel is different in the sense that court-appointed counsel, they're private attorneys. Ann Taylor and Bryan Kohberger's team, they're court-appointed counsel. So these are private defense attorneys, right? Who are not who are not salaried, in other words, by the government. They're not employees of the government. It's when the government doesn't have any public defenders available. There are attorneys, defense attorneys can, well, in some jurisdictions they may be forced, in others it's an option, right? So that they want to be on the list. And what that would mean is you say, okay, I'll be on the court-appointed counsel list, so that when the government is out of public defenders available, they go to the court-appointed counsel list. So the court-appointed counsel are private defense attorneys, right? Who people hire. They hire them, right? But the government hires them, just like an individual could hire them, to come in and represent a client who is indigent, as sufficiently indigent, depending on the jurisdiction, what is required there. So, for example, Chris and Scott are private defense attorneys. That's who I work for. And if the state of North Carolina got desperate enough, because like I said, their public defender's office is drowning, if they get desperate enough, they might actually be requiring the private defense attorneys to work as court-appointed counsel for a certain number of cases a year, to where they would have to reduce their caseload for a period of time of their private cases and take a case for the government to represent, an indigent defendant, and they would be making a lot less. So does that make sense, guys, how that works? How come public defenders get such a bad name? I've heard many people. I have no idea. Does anybody in the chat know? I don't know, Flash. I don't know the answer to that. I've even heard people use the phrase public pretender. I don't know how they get such a bad name. I'm sure there are public defenders who are really not that great, right? Just like how there's private attorney, like even with private attorneys, right? Some are better than others. Some don't really care. Others really, really care. Like, I'm so happy that Chris and Scott, who I work for, they fight for every single one of their clients like it is, like it's a death penalty case, whether it is or isn't, right? And they're so passionate about defending their clients. And but all the time they will be talking about another defense attorney, right? They have a client that came over from another defense attorney. It's like there's certain defense attorneys in North Carolina who are really lazy. And I mean, it just happened recently. Scott got a new client who had this other defense attorney, and it had been like, he'd been on the case for like a year, hadn't filed a single motion, hadn't filed anything. I don't even think he'd filed like an actual like notice of appearance, hadn't filed anything, hadn't requested discovery. And Scott's like, this court date is in a month, at which point you're either gonna, whatever your decision is, like, it's like, what? You know what I mean? And this was a private defense attorney. So whether it's public defender or whether it's private counsel, there's good and there's bad, right? So I find it very unfair that for whatever reason, there's a stigma that public defenders categorically are not, they're inept or whatever the case is, versus private attorneys being always better, because that's not the case. You know what I mean? And in fact, there's people that call our office all the time that literally say that. They're like, yeah, I'm calling on behalf of my brother. My brother's is in custody, and they were gonna give him court-appointed counsel, but like everybody says don't do that or whatever. I hear that all the time. You know what I mean? And again, sometimes there are, yeah. Hopefully that makes sense. There's good lawyers and bad lawyers out there, regardless of who's hiring them, or who's paying their paycheck, if that makes sense. Like I said, like Ann Taylor did such a phenomenal job that, like, I don't know that Bryan Kohberger could have like hired, had he had all the money in the world, I don't know that he could have found better for death penalty qualified in Idaho. You know what I mean? Okay, so all right, so this part here, hope that a defendant will be risk averse, just disgusting. Furthermore, prosecutors lack any, I already read that one, right? Most communities want the state to be tough on crime. Right there, tough on crime. Because prosecutors have an incentive to encourage pretrial dispositions, many include all possible charges in an indictment, including those with very little support. To meet minimal ethical standards, prosecutors need only show that they have probable cause to, quote, believe that the accused committed an offense defined by statute. Although there are persuasive arguments Oh my God, it's not letting me scroll. Come on. Persuasive arguments in favor of flexible charging discretion. Broad prosecutorial discretion diminishes a defendant's ability to knowingly and voluntarily enter into a guilty plea. Exacerbating the problem, quote, often it takes nothing more than a fertile imagination to spin several crimes out of a single transaction, end quote. Scholars suggest that there are two basic types of overcharging. Prosecutors can engage in either horizontal overcharging by filing charges for distinct crimes resulting from similar offensive conduct. So what that's saying is, let's take the candy example again. What this is saying, horizontal overcharging would be like you steal the one bag of candy, right? And that instead of trying to say, oh, you stole 20 bags of candy or you stole a Maserati, instead it's like the same level of offensive of the crime. Like, in other words, okay, like let's just say they were like, you stole one bag of candy and one pencil and one stick of gum, and you know, you didn't put your seatbelt on. I don't know, right? Just in other words, it's like same level, but like, as you can see, the seatbelt one might be a distinctly different charge, but the stick of gum, right, and the pencil and the bag of candy are like on the same level, if that makes sense. So horizontal overcharging, right? Or vertical overcharging by charging harsh variations of the same crime when the evidence only supports lesser variations. And that would go back to the example of like the Maserati versus the bag of candy. Usually prosecutors can choose from a number of potential charges. And we didn't read the thing referenced at the beginning, so we're going to skip that part. Oh, actually, this is giving an example that of like the hypothetical I just gave. It's going to give a much better one. So let's read it actually. In the hypothetical scenario that began this article, the street terrorism charge is a classic illustration of horizontal overcharging. The hypothetical prosecutor brought this additional charge when one, robbery alone, would have sufficed. An example of vertical overcharging, on the other hand, would be filing a first-degree murder charge when only a second-degree murder is appropriate. There we go. Or you could take the bag of candy example. Yeah. Previously suggested solutions to overcharging. Through the years, scholars have proposed various solutions to the serious problem of prosecutorial overcharging. Although thoughtfully developed, these proposals have not been adopted. And even if adopted, they would have proven ineffective in reducing overcharging. That's sad, isn't it? Scholars who offer such solutions share the belief that modifying the charges, or perhaps the charging system, will reduce prosecutorial overcharging by removing the very tool used by the prosecutors to accomplish the task. So, for example, we have this one professor suggested using sentence bargaining instead of charge bargaining, a tactic that would require prosecutors to file only the most appropriate charge and reserve any bargaining for sentencing recommendations, thus reducing any incentive a prosecutor might have to overcharge. A good example of this, just from like looking at the context here, would be like federal, right? Because the federal sentencing guidelines they're given a huge range. So I don't know, that might be like kind of a good illustration. He reasoned that if the ultimate sentence is not necessarily determined by the charges, but by the evidence, then the resulting sentence will be free of any coercion. Although a seemingly positive suggestion, it merely places another name on the same problem. Yeah, I was going to say, prosecutors will continue to have the power to offer disparate bargains and manipulate defendants. Yeah, that's a great point. They would simply be exercising that power with sentence recommendations instead of charges. It's just simply saying, it's like what he's saying here is it takes the problem and it just scoots it along. It just moves it into a different place, but the problem's still there. Now we have a different professor suggests increased and open discovery during plea negotiations. There you go, Doug. Increased and open discovery during plea negotiations, reasoning that with full discovery, oh my God, Doug, I hope you're still listening. Reasoning that with full discovery, defense counsel will be in an optimum position to evaluate the state's case and recognize if his or her case has been overcharged. This approach suggests that counsel and defendant, armed with information, will fall prey to coercive tactics, but will recognize the worth of his or her case and undertake case disposition on an equal plane with the prosecutor, as opposed to being cowed into a disadvantageous bargain. So what this is saying is here. Like, okay, in this particular case, we're saying, okay, let's just say that the defendant's been overcharged, right? Like, if we're accepting that premise for the case, analyzing it from the single, like, okay, somebody's been overcharged, right? But what they're saying is at least if they have this increased and open discovery, then while they might realize that they're basically giving in to this coercion, as it were, at least they would be on an even playing field as the prosecution. It's so sad that this even needs to be considered as if this is an option that doesn't already exist. Like, this should already be happening. They should already be on an even playing field as the prosecution. Oh my God, I cannot. Nonetheless, even with increased disclosure to facilitate the defendant's understanding of the potentially weak evidentiary support for certain charges against him or her, the risk of testing that evidence at trial remains a threat to the defendant. Let me read that again. Nonetheless, even with increased disclosure to facilitate the defendant's understanding of the potentially weak evidentiary support for certain charges against him or her. Okay, what this is saying is this, that even if the defendant has a better understanding of the discovery and the evidence against them, and that the defendant has with that been able to see, oh my gosh, like, look at all these weak evidentiary holes. Very relevant here, right? Look at all these problems for the state's case, right? All these different weak evidentiary support for certain charges. The risk of testing that evidence at trial remains a threat to the defendant. Right here, I think this sums up literally what I've been saying on all these different live streams ever since the plea deal. I've said two things. Well, one main thing. I've said that, in my opinion, this plea deal was about distrust. It was about the state distrusting their case and that they could prove it to a jury beyond a reasonable doubt. And it was about the defense, the defendant, distrusting or not trusting that they could seat a jury who would be fair and impartial. And that's literally what this is, right? It's like saying you've got a case where there's weak evidentiary support for the certain charges. So that's the state having a weak case, or a case that might not be able to get a guilty verdict, right? But that if you're the defendant, the risk of testing that evidence at trial remains a threat to the defendant. And why? Because a jury. That this paragraph is literally what I've been saying I think happened in this particular case of the plea deal. So Bunny is saying that when she got a divorce, you get billed for every single email. Yeah, that's interesting. So, and that would be, family law is a whole different thing, right? A whole different animal. One thing I will say that's interesting to note is that with Scott and Chris, right, being defense attorneys, they charge a flat rate. And I think a lot of defense attorneys do that. And think about it, right? I guarantee you that no matter what their flat rate was, if they were to charge, like the way that a lot of civil lawyers do, for example, like what Bunny Murphy's saying happened to her, like if these defense attorneys were charging for every email and for every phone call and for every extra thing that they do, or time, even just billing by the hour, no one would ever be able to afford to have an attorney. And that amount would be, I don't know, 1,000 times more than what they're charging with a flat rate. I will just say that, like, these defense attorneys that I work for, and I'm sure many other defense attorneys, they charge a flat rate. They are doing that to benefit the defendant, and it's not about how can I make the most money. Like, literally, it's not. You should just, for example, Scott, like, we had a holiday weekend, right? Courts are closed Friday, right here. Like, courts were closed on Friday. You had Friday, Saturday, Sunday. Like, Scott, for example, basically lived at the office, the law firm, the entire time. Friday, Saturday, Sunday, trying to work out this one particular federal case. This young kid who's about to be sentenced and he will be doing a sentence in federal prison. And he literally just came in Friday, Saturday, and Sunday, even though courts are closed, everything else is closed, literally came in, and you should see his office. It's like, it looks like a tornado hit it, literally trying to see what can he do for this client who basically still owes him a ton of money and all. I mean, it's just, I can't say enough good things about those guys. I love them so much. And I'm just so lucky to be working with them. So Flash is asking, a 15-count indictment is overcharging someone. I can't say without knowing the facts of the case, right? It could be appropriate. I don't know. I mean, that could be like that category of the horizontal overcharging, right? But I mean, there's plenty of clients that we have that when you look at their case number, and I'm not usually seeing indictments. These are just well, we do have cases where there are indictments, but a lot of these that I'm seeing are just like your regular like information, charged by like whatever police officer was the one responsible for charging, what have you, the magistrate. But anyway, what I'm saying is we have plenty of clients. I see them every day where I pull up their case number for one case file, like what that means is one instance, right? So like one event, like on this day, this one time when they were pulled over or whatever, or stopped by law enforcement, right? That in that one event, I regularly see 15 plus different charges on that one event. And so the horizontal overcharging would be like if there's a lot that are basically the same, right? It's redundant. And then the vertical overcharging would be, again, like we gave those examples, right? Like they're being charged. I'll tell you what, guys, I had somebody call the other day, a new client, and they had check this one out. You guys are gonna love this. You guys are gonna love. Sorry, hate this. I was being sarcastic. Check this one out. This dude got pulled over, okay, and was given a DWI. Check this shit out, guys. No field sobriety test, no breathalyzer, no blood draw. I'm gonna say that again. This dude, where I live, and is now a client of I believe he's one of Scott's clients, DWI, charged with a DWI. They did no field sobriety test. They did not administer a breathalyzer, and they did not do a blood draw. Unbelievable, absolutely unbelievable. Because those are ways that you get probable cause in North Carolina, and I think probably most, if not all states. Like those are your standard probable cause for a DWI. None of them. It blows my mind. And this is somebody who has no prior offenses. I'm sure Scott will figure out a way to be like, hey guys, did y'all have a temporary moment of insanity where you charged this? Because like, what are we doing here? That's terrible, Bunny. I'm sorry. That really sucks, right? That if you've got a divorce attorney who's like, God, it's just awful. Like thinking about people just trying to scam people out of money is awful anyway in any situation. But like thinking about attorneys that do that when you've got people that are coming to you for help in like their most difficult times in life, whether they're injured in a car accident or whether they're getting a divorce or whatever the case is, or it's a criminal defendant. If there are defense attorneys out there that are charging the criminal defendants by the email and by the minute, it just doesn't, it's not I don't like it. I don't like it at all. Yeah, by the way, Doug, I hope you heard, I read something here a few minutes ago that I was like, it was literally going to what you were talking about. I think it was with Discovery, and I was like, I hope Doug is still here. So are we going to have a serious talk? I don't know what you're talking about, Twiz. About what? On what basis was he charged? Bunny, I have no fucking idea. I have no idea. Literally no idea. Great question, though. I have no idea. Yeah, Twiz says his friend just got charged but doesn't drink or do drugs. I mean, I've got horror stories, guys. Have I ever told you guys my horror stories when I lived in Boone? I was pulled over all the time. And I didn't have any drink of alcohol until I was 26. Like I didn't. So basically I was pulled over all the time because of my bumper stickers. And by the way, they were all things like related to classical music, like nerdy, like Bach off, I'm a musician, or I'm a fermata, hold me, things like that. And maybe some of them were kind of hippie, but like a lot of them were nerdy classical music. And like I was pulled over, and right, Boone, by the way, is like the ratio of law enforcement to citizens is bizarre. Like you can plop yourself anywhere in that town, and you will within eye shot be able to see like, I don't know, maybe at least 12 cop cars. I don't ever see cops where I live in Greensboro, same state. I never see, I like literally, it's just crazy, right? But anyway, there was one time where I was followed. Okay, I lived at the time, I was a junior in college. I just left the music building. It was late at night. I had my violin in my car, and I was driving out to where I lived in this log cabin in Vilas, which is just outside of Boone. And it's anyway, that's a whole other story. The cabin is crazy. But anyway, I was living out there, and I noticed I was being followed. And like, and when I say followed, it's like you're on the road, but then it's like in order to get to this cabin, you go way off the fucking beaten path, right? Where like there's no street lights, there's no stop, there's nothing out there. It's just like farmland that this family owns, and there's like nothing out there. And so this car was following me, and it kept following me and following me. And I'm turning, I'm getting closer to the cabin. And so I'm like driving more and more onto these roads where it's like, what are you, and anyway, where there was no street lights, nothing fucking out there except some cows and horses, like lights come on. And I was like, what? I'm telling you guys, this cop was like, where are you coming from? I was like, the music building. I'm a music major. I was practicing. I'm not even kidding. When he was like, you were whatever, try to swerve, whatever he made up, right? But here's the thing. I was so mad. He said, I can smell alcohol on your breath. And I said, I have never had a drink of alcohol in my life. And he said, get out of the car. We're going to do a breathalyzer. And this cop, by the way, I learned after this, that this cop had been a law enforcement officer in the neighboring town of Blowing Rock and had gotten fired from there because he shot a black man on his own property and like had no reason for it. And like, I think the dude died. And so they just put him over into the Boone PD. And this dude is the dude who pulled me over and said, I smelled alcohol in your breath. Get out of the car. And I have learned after the fact that all of this was unlawful, all of it, literally from start to finish. But anyway, so I get out of the car to blow a breathalyzer and I blow a 0, doesn't even apologize, doesn't say anything, literally says nothing. I blow a 0 and he says nothing after telling me he says, you're lying. I can smell alcohol on your breath. Unfucking real, dude. I went home in tears just at how mad I was and thinking about just the injustice of it, right? It's like, like what? Anyways, I could elaborate on that story, but that's enough of that. So, ugh. So Twiz, what were you saying about we need to have a serious conversation? I have no idea what you were talking about. Yeah, I'm with you on that, Doug. I mean, there's a lot of fucking horror stories. Like Boone and Blowing Rock, really, I didn't really realize it as much when I was living there because I thought it was normal. But like now that I've moved back to Greensboro and like working in Winston, like there's a lot of fucked up shit that's going on up there. I didn't really realize it was so messed up, but I do now in terms of the law enforcement. It's really messed up. Did I sue that mofo? I didn't, and I didn't even know that I could. And I'm sure now the statute of limitations has certainly passed. I mean, if I had known what I know now, although I will say it's really difficult to find an attorney who will represent you when you're trying to sue the government. I have people calling all the time that are like, I want to sue, and then name a branch of the government, whether it's whatever, a school or a police officer or whatever. And it's like, good luck finding an attorney who will represent you on that, because those cases are basically impossible. Like no one wants to take them because it's like impossible to win those, basically, which is, and what I'm saying is, even if it's completely valid, right? You know what I mean? Did who hear what now? What's going on? Hold on, let me see what you guys are saying in the chat. I don't know are you guys talking about me? What is happening? Did Heather hear? Oh, Heather's best friend lived in Blowing Rock? Really? Say magistrate? I don't know. I don't know. Magistrate. Magistrate. I think I say it like magistrate if it's possessive, like with the magistrate's office. But when I say it just like by itself, like singular, I say magistrate, I think. I mean, now I'm thinking about it, so it's like, yeah, but I think that's how I say it. I know, Flash, it's awful. Racist cops. I know, it's terrible. I said it already, Twiz. So my point was, though, I think I say it both ways depending on the context. Anywho's, so okay. I'm going to read this one part one more time. Nonetheless, even with increased disclosure to facilitate the defendant's understanding of the potentially weak evidentiary support for charges against him or her, the risk of testing that evidence at trial remains a threat to the defendant. Consequently, risk-averse defendants confronted with the significant downside of an unfavorable trial verdict may be motivated to plead to the lesser charge or sentence, fully aware of the weak nature of the state's case. Bam, that's it. That's literally this, in my view. Fully aware of the weak nature of the state's case. Notice, guys, notice that nowhere in any of this discussion, nowhere is it ever even a question of, is the defendant actually innocent or guilty? It's not a concern. When you're a defense attorney, it doesn't matter. It's not a question that you ask. It's not a question you ask yourself. It's not a question you ask your client. It only is a question that comes up in chats, right, on YouTube, or I guess maybe on like Court TV or Law and Crime. In the world of law, it has no place, right? It's not even a consideration. And that's why you're not seeing it being mentioned. Another scholar views the criminal codes themselves as the problem. After finding that the expansive and often unnecessary litany of crimes allows prosecutors to, quote, stack charges, end quote, he acknowledges that reducing the codes by removing outdated, marginal, or unnecessary duplicative code provisions would have little effect on the prosecutor's pre-bargaining power. As this professor correctly points out, plea bargaining was in practice before the growth of criminal codes, and the majority of prosecutions occur under a limited number of statutes, even though other options are available. For example, he notes that approximately 85% of drug crimes constitute drug sale, delivery, possession with intent to distribute, or simple possession. I see these all the fucking time. But that a multitude of other charges exist, each carrying distinct grading and sentencing variations available to prosecutors. With the variations of grading available, prosecutors can charge the same crime at various levels and be squarely within the criminal codes of many jurisdictions. True. These provisions provide varied offense definitions, as in the crime definitions, and permit the prosecutor to choose from among them. Yeah, that's accurate. Furthermore, Brown recognizes that it is not the number of charges, but rather the sentencing implications of those charges that make plea bargaining such a powerful prosecutorial tool. So what he's saying is this, that you could have 1,000 charges, but let's just say they're all misdemeanors, right? The number of charges is not nearly as daunting as, let's just say you've got one first-degree murder charge versus, again, stealing a bag of candy. Let's just say you've got 1,000 of those, right? It's not the number necessarily, right? But it's the sentencing implications. So one charge obviously can be way worse than a bunch of other charges. Removing the duplicative code provisions would not remove the incentive to plea bargain, nor the prosecutor's power to offer charges with higher sentences. Another professor has recommended altering the charging threshold, believing that elevating the charging standard above probable cause. Oh, guys, look at this. Elevating the charging standard above probable cause will force prosecutors to file more meaningful charges. I like this idea. As the Supreme Court stated, quote, it is critical that the moral force of the criminal law not be diluted by a standard of proof that leaves people in doubt whether innocent men are being, and won't let me scroll, okay, are being condemned, end quote. An enhanced standard may be one solution. However, the concern remains whether prosecutors would comply. Another general approach focuses on prosecutorial oversight. I love this. This is, I'm so happy reading this, right? This is literally the question that I had at the beginning of the live stream, right? Which is like, what are the pros and cons? And is there an actual solution to this? Is there a solution? They are literally going through my exact thinking process, thought process that I've been having in my head, conversation in my head. They're going through literally step by step all the different options that have been discussed by legal scholars and what could be a solution, basically, like another approach, right? That's what, and they're going through all the different things that have been discussed. I love this so much. So, another general approach focuses on prosecutorial oversight, suggesting that regulating prosecutors themselves is the solution to overcharging. Scholars who advocate this approach suggest various measures to provide oversight of prosecutors both during and after the charging process. For example, Professor Richard Burke recommended creating a notation on the case file indicating that the original charges were dropped pursuant to a plea bargain. This would allow the judge to make an inquiry into the original offense and determine if the plea bargain was coercive. That's a good idea. I think that's a good idea. Kane says he got a speeding ticket in South Carolina for going 2 miles per hour over the speed limit. I have seen those. I have seen those in my short time so far. I have seen plenty of people calling in with a speeding ticket for shit like that. And it blows my fucking mind, especially because I speed like a crazy person. And again, in Boone, I'd be getting pulled over every day for literally nothing. And here, I've yet to get a single speeding ticket, but I speed like a crazy person. Again, ratio of cops to people, it's crazy what a difference it makes. And also, I guess, potentially the type of law enforcement or whatever. Mittens for Kittens, welcome. I think a new squirrel friend has joined us, guys. Everyone, welcome, Mittens for Kittens. Whose mom got a ticket for driving too slowly on the LA freeway. That's wild. I wonder how that even, not a speeding ticket, but what would they even call that? Slowing ticket? I don't even know how you call that. That's wild though. But hi and welcome. I shall call you Mittens. Sad that, again, the concern is whether prosecutors would comply. I'm just shaking my head over here, guys. Another general approach focuses on prosecutorial oversight, suggesting that... Oh, wait, I already read this one. And I thought this was a good idea. The part where it was like making a notation on the case file. Similarly, another law scholar suggests that prosecutorial agencies should promulgate policies requiring supervisory review and approval for charging and plea bargains, noting the problem of prosecutorial self-interest, which motivates many attorneys, quote, to safeguard their reputations, win-loss records, and egos, oh my God, by not risking losses at trial. This particular scholar advocates that supervisory review of written plea agreements would force prosecutors to justify their offers without relying on self-interested reasons. They further speculate as to the role judges could play in reviewing plea bargaining through increased judicial oversight to assess the strength of prosecution's case and determine a proper sentence. Although acknowledging the fear that judicial involvement in plea bargains could result in judicial bias if the case proceeds to trial, this scholar counters that courts, I love this. This scholar is arguing with himself. Classic lawyer, right? Classic lawyer. The lawyer makes a point and then argues with himself. Love it. Counters that courts could automatically reassign cases to different judges if a defendant rejects a judge's advice to plead. Alternatively, if judicial involvement is too radical or not feasible, non-judicial mediators could give advice and try to debias the parties. That's a good thought. I hadn't thought of that one. Non-judicial mediators could give advice and try to... That's a great... Bring in a third party. Interesting. That's a good thought. This particular scholar also focuses on internal regulation, suggesting a reward and promotion system that would permit feedback from a range of sources. This feedback would be compiled and used by supervising prosecutors to evaluate the performance of their peers. Oh, they have to evaluate their peers. Interesting. Supervising prosecutors would use these performance reviews to assess, quote, zeal, investigation, research, rhetorical skill, professionalism, ethics, diligence, courtesy, respect, and satisfaction, end quote, when making promotional decisions. So in other words, instead of politics, right? This thought, that this avenue that they're going through here, the idea here would be performance reviews that are done by their peers, right? I like this because you know why? It does appeal to the prosecutor's egos, right? Like, in other words, the idea, like, who better to assess prosecutors than us? You know what I mean? It appeals to their egos, but then instead of assessing their own job done, well done or not well done, they're assessing their cohorts, if you will, the other prosecutors, right? But again, instead of being like a political thing, right? It's like you would get a promotion based on your zeal, ethics, diligence, courtesy, respect, and satisfaction. When collecting this data, and I honestly, I think that would definitely be an incentive for them all to try to strive harder, because their sense of their ego, again, would make them want to do better than the other dude, right? Which is a win-win. It's like, I'm going to out-ethics you, right? Like, go for it, right? Like, I like that idea. When collecting this data, supervising prosecutors would survey defense lawyers and judges. Oh my God, that's brilliant. Who regularly interact with the junior prosecutors, as well as the victims and defendants involved in their case. Wow, that's brilliant. So in other words, it's like, in order to, the checks and balances, right? In order to decide whether or not the prosecutors are assessing their other prosecutors accurately, they're going to have the defense lawyers weigh in and the victims' families weigh in, right? Would you guys agree with how they assessed this prosecutor? I like that. It's really clever and creative. I like this. I like this. Theoretically, the defense lawyers and judges would provide information regarding overcharging, and prosecutors who routinely overcharge would be censured by not receiving promotions. Who votes for that one? Who votes for that one? I love it. I love it. I love it. Yes. Make them stay in their lowly totem pole spot because they are overcharging. Punish them. So this scholar's approaches suffer from the general concerns that afflict any internal oversight system, specifically that policing one's peers is generally ineffective. So in other words, they're saying, well, while this sounds great, there is one potential pitfall here, which is, can you really trust the prosecutors to effectively assess other prosecutors? Fucking hell. Wow. Each of these proposed solutions is thoughtful and provides blocks to build upon. It is with appreciation of these proposals that the remedy ventured hereafter is constructive. So this scholar who's writing this entire beautifully put together legal, I think it's from a legal journal, anyway, is going to offer a new approach. Oh my God, I have not read this yet, guys. I'm so excited to see what he comes up with after assessing all these different approaches. Are you guys loving this? I'm freaking loving this, but this is like really super law nerdy. But I think this is really important, right? This is really important. Going back to this whole thing, right? When we know that 90 to 95% of criminal cases resolved with a plea deal, there is maybe potentially nothing as important in terms of the criminal justice system here in the US. The most important fucking thing we can maybe do to get it right is to assess the nature of plea deals, right? We all talk about juries being fair and unbiased and then seating a jury and all that, which is super fucking important. But when you consider only 5 to 10% of cases go before a jury, it's like, fuck. Like this issue of the plea deal, you can't even compare the two, right? In terms of the effect that this has on the criminal justice system as a whole. And defendants as individuals. And there's so much to consider here, right? There's so much to consider. That's why, like I said, I've been meaning to do a live stream dedicated to the plea deal. And I'm already seeing this is going to be multiple live streams because I think this is a really, really, really important issue. And there's so much to think about. And I feel like I'm learning a lot. Hopefully you guys feel like you're learning a lot as well. And I love that this is kind of combining, right? Like due process and constitutional rights and like real world problems with like real world solutions. But it's also, I feel like in a lot of ways too, like a philosophical and creative exercise, which I also love. Like this is like my happy place. And that too fast chiming in, right? And that's why one of the suggestions mentioned previously here was like, what if the arrest standard was higher than what if one of the solutions to raise the bar from probable cause? Like, do we need to, like, is that one of the solutions, right? Do we need to assess probable cause and like raise that bar up? You know what I mean? I mean, I think that I would vote for that. But the problem that they found with that consideration is that the prosecutors would still find a way to get around it and overcharge. And in other words, it wouldn't. The whole thing here is basically how can we stop prosecutors from being unethical as per the rules of the ABA and literally their oath of office by overcharging in myriad ways, which we've talked about here, right? Whether it's horizontal or vertical, whether it's through the sentencing or whether it's through the charges themselves. How can we stop them? Like, again, we shouldn't even have to be doing this because they should be following their ethical oath and the guidelines. They shouldn't be doing this. But it's like they're doing it. Like they're doing it. And like, what can we do to stop them? And what so far this is showing and all of these suggestions is that it's really fucking hard to stop them. And that's fucking a problem. But some of these suggestions laid out seem to have less ways for the prosecution to get around them. And again, where we're going to get to next is this scholar's taking it all together and being like, what is potentially a good solution? How can we stop the prosecution? I mean, dude, just sorry for anyone who I've missed in the chat because I'm just reading and getting all excited about all this stuff. Public oversight is the only answer. I mean, Tonka, I mean, I agree. I think I see what you're saying. I do think having oversight by defense attorneys, though, one of the solutions suggested here, like, I think it may be in addition to, or potentially the only other category of people that could maybe like accurately assess prosecutions overcharging, what, like the defense attorneys, right? Because like, I think that goes without saying, but I understand what you're saying. Working group peer reviews, yeah. Tonka saying that's like the cops, politicians investigating themselves, right? I know, right? I see what you're saying. I mean, it is, isn't it? Hopefully you guys find this interesting. And again, massively important. This is massively fucking important, guys. So I'm gonna pause on this one. We've got way more to go on this one. I have another one too. This is a much longer one from the UCLA School of Law. And this one is called Leveraging Death. I didn't even plan this, guys, but how many times have y'all heard me say the word leveraging? How many times have you guys say that? Literally, I mean, that was the thing that I came up with the other night, is like, basically the plea deal is a contract and it's all about leverage. I mean, I didn't even know that this was going to say, but essentially it looks like this particular article is going to be dealing especially with the death penalty in terms of plea deals, right? So like the one we've been reading is like literally all the different considerations, right, with the plea deals. And what's it called? Coercive plea bargaining, the unrecognized scourge of the criminal justice system, right? And then the next one's going to be specific to death penalty cases, leveraging death. And after that, what we will get to is one of the things I'm super fucking excited about, which is this study that I found where they surveyed a bunch of defense attorneys. And this was recent. They surveyed a bunch of defense attorneys and literally asked them, like thinking through all of your different cases, right? Like, how many do you think pled? Why do you think they pled? And they do actually ask the question of them of how many of your clients that pled did you think actually were factually innocent, or did you know for a fact, did you know were like innocent, but they pled literally because of this, the being railroaded, the court, literally what we were talking about, right? And they go through all of it and they go step by step by step, and they've got statistics, and this is going to be so exciting. It's like the culmination of all of it. Like, I'm so excited just to go through this with you guys. I looked at a little bit of it, and as I was like, oh my God, I'm too excited, and I want to do this with y'all, not by myself. Because like, it's really, really, really interesting. And they don't just answer like yes or no. They actually give their examples of their own clients. Obviously there's no privilege that's being dispersed or what have you, right? But like, anyway, it's really interesting. Like, they get to provide answers, not just yes or no, but they get to actually provide, like, they get to answer it in as full fleshed out as they want, right? Really, 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 really good stuff. Thought-provoking and interesting. But we're going to have to call it for this one. This is going to be a multi-part series, as I thought might be the case, because my voice is kind of going. Can you guys tell I'm losing my voice? But my voice is kind of going, and this is going to be a good stopping point, because we're going to get to a whole new chapter here with chapter 6 of this. Guys, do y'all want me to put a link for this? Oh my God, you guys can't see it. Sorry. This is what I was saying here. Next up will be this next chapter, chapter 6, right? But I was going to say, do y'all want me to put a link for this, this in like the video description, for any of you guys that want to be able to go through it? We didn't even start at the beginning, by the way. Let me just show y'all. So we're on page 29. Let me make a note. So here's the thing. Let me just show you guys. There's way more to it than this. So this one, oh my God, scroll. So here's the table of contents. So we have ethical and prosecutorial duty. I mean, we probably should read the entire fucking thing. I think we probably should. Here's where we started from. We started here. Overcharging, the precursor to coercive pleas. And what we read through was this and this, okay? And look, I feel like that much was like incredible, interesting, so much wonderful information. So what's highlighted is what we've read through. And I feel like this is a really, 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 really well put together and well written. Like, I kind of want to read the whole fucking thing. But like, we did not read any of this, and we have not read any of this. And what I was saying is we could start with chapter 6 next time, but now I kind of feel like we should go back to chapter 1 and go through all of it. But let me know if you guys want me to put the link to this in the video description. If you guys are interested in being able to go through this on your own time as well. I'm just so glad I found this one. I love it. I love it. I love it. Hopefully you guys like it. Have AI read it now. Let Twiz read it. Oh my God, that's not a bad idea. Twiz, do you want to do Twiz reads? We love Twiz reads. It was so fun. Started from the bottom, now we're here. Started from the bottom, now the whole, started from the bottom, now what song is that? What song is that? Too fast? Do you want to do Twiz reads? It's not a bad idea. Maybe if we do Twiz reads, should we go back to Roman numeral 1? But are you guys, do you feel like you're getting something out of this, y'all? If not, then we don't need to do multiple live streams. I don't want to just be the only one who's all excited all by myself. Do you guys feel like you're learning something? Are you guys, is this, you guys want to carry on with more of this? Tonka saying an unfortunate truth is that the majority of people don't care until something directly affects them or their family. You're right. You're right. And it is very, very unfortunate. I agree. Very much unfortunate. Yeah. Next time or now? You can do it. Do you want to do it now, Twiz? Do you want to do Twiz reads? Truth Seeker chiming in. Love it. Welcome back, Truth Seeker. Oh, it's Drake. Okay. Thank you. Too fast. Appreciate it. Started from Kane is putting a bunch of ones in the chat. I don't know what that means. Kane, are you broken? Truth Seeker saying yes. Interesting. Glad. Good. Love it. Flashes I learn every time you stream. Love it. Learn into squirreling, as I always say. Twiz says his laptop is out of commission. Okay. Well, maybe next time then, huh? Maybe next time. I mean, you were on Kane's earlier, weren't you? Which is, I mean, I'm not gonna, let me just put it this way. I'm not gonna coercive plea bargain you into into doing Twiz reads if you feel like that you don't have the capacity. Twizzle scripture. Let you know before. Okay. Well, I mean, yeah. We can continue on with this tomorrow night, guys. We can do part 2 tomorrow night. And we can have Twiz reads as well. Oh, you got off because of your laptop. Okay. So yeah, we can do another one. We can do part 2 tomorrow night. I feel like we just want to go back and read this entire fucking thing. I love this. And again, it's like we've got so much more here. And then we've got a whole other one dealing specifically with the death penalty. And it blows my mind that they're even saying the word leverage. Because literally I came up with that because of thinking of like contracts. And like, I'm like, wow. I mean, I guess there was a reason why that seemed like the way to describe it to me in my brain. So, and then again, we have this other one, and there's more. I mean, there's more. I picked the ones that I thought looked like the most thorough and put together, and also more recent, because some of the different scholarly articles and stuff on plea bargains are from like, there was one that looked really good, but it was from like 1973, and I'm like, it's just not going to be as, I don't think it's going to be as helpful, because these ones are that I decided to use are more recent. But there's definitely more. But I think this is going to be plenty. I mean, this one's 36 pages. The other one is 79 pages. And then we have that other study to go through, which is very, very long. And so it doesn't even have page numbers. But yeah. Flash is going to bed. Good night, Flash. We love you. Kane's had a great conversation. I might have missed that. I was there for some of Kane's when I was driving home from work and stuff. I was listening, but I couldn't really be in the chat because driving. And then after that, I had to go teach a lesson and get ready for this live stream and stuff. So I might have missed. I mean, not that it wasn't great conversation. I just feel like maybe I missed something on Kane's because I was there for the first, I don't know, whatever, like hour and a half or something, maybe. So Kane, I'm sorry I missed it. If I missed it, I mean, when I was there, it was like, I think before Twiz came on. y'all were having, I mean, it was great chat, but anywho's. So Kane is getting sleepy. Flash is going to bed. In charge of letting the dogs out. I know how you feel about that, Flash. I know how you feel about that. Appreciate you for being a trooper on that one, right? I only tune into the I didn't say it was crappy. I heard one part, where was it? I think the last thing I heard was you guys were trying to get Jen to come on or something, and she was like on the phone, and then everyone was talking about Kane not using StreamYard, and then she was like, this is dumb. that was like, I think the last thing I heard, where then I had to go, like I said, go teach and stuff. But anyways, so but yeah, I didn't get to hear, I don't think I got to hear any of Twiz on there. I might have heard him like say hi, but then I don't think I heard him say much else. I don't know what happened. But anywho's, okay. But guys, that'll be it for this live stream. I appreciate you guys for hanging in here with me on this. I know it's super nerdy, but I love it. And I love you guys, and I love the Scroll crew, and I love that, we are here for each other to be supportive and to have our open minds and to learn something and to love each other and to, really thoroughly assess the criminal justice system, right? Through the lens of the cases that we are following or covering, and also through scholarly articles and through the federal rules of criminal procedure, as I like to call it lovingly, FRCrimP. Doug, hopefully you heard that one as well, because I don't know if you knew that I call it that, the FRCrimP. Because, and the reason for that is the abbreviation for the federal rules of criminal procedure. You have to differentiate it from the federal. So, okay. So federal rules of civil procedure, you abbreviate it like this. Now, you might say, oh, wait, FRCP, but wait, federal rules of criminal procedure. Uh-oh, could people get confused? Yes, they could, because the initials would be the same. That is why we have the FRCrimP. So that means that's how this, I'm going to put it in the chat here. So it's like this. For criminal. So people don't get confused. The FRCrimP. Truth Seeker says that they love listening to me. Well, I'm very glad. I'm very glad you love listening to it. I'm glad that you guys are enjoying it and learning things. Very, very good. I don't know, what video are y'all talking about? Play the video from earlier. I didn't see anything about any video. What is it now? What video? You're welcome, Tonka. You're very welcome. That's funny. P Fox is saying Flash. So you let the dogs out. Mystery solved. Love it. Love it. This is the same dog that has been, peeing on Flash's socks, eating Flash's socks, many things. Who's going to send it to me? Okay, I don't know if we'll watch it, but I'll see what it is. So he's going to send it. He says, oh, I forgot to check to see if Scott, okay, while Twiz is sending, guys, Scott got back to me, one of the defense attorneys. Okay, so here's what I said earlier. I said, quick question. This is right front live. I didn't know if he's even going to be awake. I said, have you ever had a case where you thought it was in the best interest of your client to take the case to trial instead of accept a plea? Here's what he said. Absolutely. I have some right now. Oh my God. That means I know these cases. Facts aren't strong for the state. Plea deal isn't very good. So it's with the risk or a combination of both. Oh my God. And you know what else, guys? I can have him elaborate on this tomorrow, and I can find out exactly where's that threshold for him, right? In other words, how poor do the facts have to be for the state? And how shitty does the plea deal have to be? This is really interesting, right? I'm going to read this again. Here's what I texted him. Quick question. Have you ever had a case where you thought it was in the best interest of your client to take the case to trial instead of accept a plea deal? And he said, absolutely. And then he followed up with another text. I have some right now. Facts aren't strong for the state. Plea deal isn't very good. So it's with the risk or a combination of both. And dude, if he had given any names of like the like, for example, like the client's name, I would know exactly which case he's referencing. And that's, oh my God, how interesting. So I'm going to continue that conversation with him tomorrow. And I did not ask Chris. So I will ask Chris tomorrow. This is so amazing to be able to get their perspective on this, especially because like I know these cases that they have. And anyway, wow, I just like the real, wow. I don't know, man. Amazing, right? That answer actually surprised me. I kind of thought it might be like once in a blue moon, but he's like no ifs, ands, or buts about it. Absolutely. I have some right now, as in right now, more than one. That really, I was not expecting that. And I'm so happy to hear that. I mean, not in a way, because clearly what we're dealing with is North Carolina up to the same fuckery we were just reading about, right? Overcharging and not offering a good deal, offering a shitty deal. Disappointed in North Carolina for that. But I'm so proud to have somebody like Scott representing this client. I'm happy for the client that they have Scott in their corner, because Scott's amazing. So is Chris. And I'll ask Chris the same question tomorrow and see what he says. So I think Twiz sent me the video. Cops humiliated by angry victim. Well, it's got a commentator on there, Twiz. I'll take a look and see. I don't know that face. I don't know what channel. And I don't know if it's something that maybe I can find the video without the dude's face on it. I don't want to it's one thing when it's like a channel where it's like, I watch it all the time and basically, I don't know. But if it's somebody like that, I don't even know who that person is. I would feel maybe kind of weird. I don't know. I'll take a look and see. But what I can also do is we can also put this in the Discord, and then anyone can just watch it, I guess, too. So put Idaho in that list. Definitely put Idaho in that list for sure. Yep. A little nuisance flash referencing the dog. That's funny. Did Twiz find his twin flame last night? Oh yeah, who was your twin flame, Twiz? I forgot. Wasn't it I forget who you were joking about with that. I forgot. I don't know that channel. It doesn't say the name of the channel on what you sent me. It just has a person's face. Watch the whole series of Suits at night. During which trial? Too Fast? My mom watches that show, Suits. She says that I've never seen it. She says there's a character on there that reminds her of me. I'll say this how she says it. She says there's a character on this show that reminds her of me when I become an attorney. That's what she says. I don't know anything about the show. I don't know who the character is, but that's just what my mom says. So she'll be like talking about the show. Oh, this made me thinking of you. Oh, you're saying during this trial that's not happening? I guess you have more time to watch Suits then, huh? Yeah, we'll have Donna. Edelson. So anyway, guys, y'all are awesome. I love y'all. Good luck with the dogs, Flash. Good night to anyone who's going to sleep. Fingers crossed that the laptop will be working well for Twiz tomorrow, and if we can do Twiz reads, that will be amazing. But other than that, that'll be it for this one. I love you guys. Thanks so much for being here and being the best squirrels in the world. And I'll see you guys tomorrow. But for now, squirrel out and my homies. Okay, let's just go.